Hi, you're welcome again to the RPC challenge with NK. My name is Bolu, and today I'll be discussing employment in criminal matters. Now, criminal matters often have two sides. So there's often the prosecution side and then the defense side. Now, it's important to note that there are 6 sub-rules in Rule 37, and the first 3 speak to the defense side, while the last 3 speak to the prosecution side. So let's get into it. Now, the very first sub-rule says that when a lawyer takes up defense of an accused person in a criminal matter, is expected to exert himself through all fair and honorable means to put all matters that are necessary to the cause of justice before the court. He also says that lawyer cannot stand for bail, neither can he offer to stand for bail for any accused person that is representing or that his law firm is representing. Now, sub-rule 2 says that when a lawyer accepts the brief for defense in a murder case, it is deemed to have made a solemn undertaking that he will personally handle that defense, and this rule, of course, is subject to all sufficient unforeseen circumstances and provided again that his fees are paid. Now, sub-rule 3 says that when an accused person adduces evidence or gives facts that clearly and credibly show his guilt, the lawyer cannot give testimony that he knows to be false, neither can he give evidence that is contrary to what the accused person has already said. Now we move to the prosecution side. So this one, to remember, it has 3 sub-rules, and the very first one, which is sub-rule 4 under Rule 37, says that the primary duty of the prosecution is not to convict, but rather to see that justice is done. I'll say that again. It is important to know that the duty of the prosecution is not conviction, rather to seek justice. Now, sub-rule 5, it says that when a prosecution counsel, a prosecution attorney, cannot institute a charge or cause to be instituted a charge where he knows that that charge lacks probable evidence. So he cannot institute a charge that is lacking in probable evidence. And very last sub-rule 6, it says that the prosecution counsel shall not secrete witnesses, neither shall he hide any facts that are necessary to establish the innocence of the accused person. Rather, is expected to make a timely disclosure to the defense attorney, or rather the defendant's counsel or the defendant himself, where he doesn't have a counsel, of any fact, of any evidence that would mitigate the guilt, or completely negate the guilt of the accused person. I hope you've been able to learn from this.